Hi, now we're finally getting into the meat of the course. We're finally getting into the actual substance of the law. Now, we spent a few weeks already talking around the broader themes and talking about how the different parts of the law relate to one another, and I think that's very important to do that before we start digging in depth into that law, so that we understand how things interrelate and how they connect. So hopefully you've been able to make sense of what's been going on so far. It's all fairly self-explanatory by now, and now we're actually getting into the nitty-gritty and actually drilling deep into those issues. Now, one thing, and I remind you of this quite a bit, but it's worth reminding you, is that if you don't have your doctrine of separation of powers completely on board by now, it's going to be more and more difficult from here on in. So if you're not really clear at what executive power is, what legislative power is, what judicial power is, and why those things are separate, and what the constitutional reasons for those are, things are going to be more difficult from here on in the course. So please go back and review that material, and please ask questions either in the workshops or in the forums if there are things you're still not clear on. But it is really, really important at this point that you know that, because otherwise some of these things are going to be fairly mysterious as we go on. All right, so let's have a brief overview. There's quite a hefty reading for this week, and not a lot of it is terribly difficult, but there's a lot of ground that's covered, and there's a lot of things that's just really important to make sure that you know, particularly when we go into the sorry, it's my dog making that noise. Particularly as we go into the principles of administrative law in detail, and we understand how those fit together. So the reading from the textbook this week is really about the history of judicial review, how it was codified, and what has happened since then. And really the difference between the textbook and the readings in this course is the readings cover all the core important materials, and the textbook talks about the issues. So your study guides will tell you the basics and get you on board with what's happening, but your textbooks will tell you, well, what does it mean? What's happening? Where's it all going? And that's why I've picked that particular textbook. One of the reasons why was that it adds that interest. It actually adds the current issues and admin law aspect. So there's a chapter from Billings and Casamidis, and it's a bit of a review and an overview. You don't often get this in law text, a bit of a review and an overview of what's been going on and why. All right, so let's get into the materials this week. The first thing we talk about is what judicial review is and how it's different from merits review. Now, this is retreading what we've talked about before, but it gives you a little bit more detail about where it comes from and why it exists. And again, we see our friend, the separation of powers, come up again. And particularly the problem with the overlap of judicial power and attempts in the past to delegate that power to other bodies and tribunals. We figured it out now, and we figured out how to separate those things, but there was a history in Australian constitutional law where we had a great deal of difficulty with giving the same sets of powers to administrative and judicial bodies. So that's all constitutional law. I know some of you haven't done constitutional law yet. We kind of hope that you had, given this is a second year subject. But you'll need to dig into some of that, I think, to make sense of things. And, you know, as I said before, if you're still facing problems, there's still difficulties, please ask questions about it. All right. So we've got some details of the different courts that have judicial review jurisdiction. So far, so good. You can read that for yourself. And a bit of discussion of the Administrative Decisions Judicial Review Act. There's a typo on page 16. The Administrative Decisions Judicial Review Act. And this was an act which codified the common law in relation to judicial review. So judicial review has a long-standing history, and later in the chapter we talk about the prerogative writs, certiorari, mandamus, and so on. Those go back to the time when the king had the power to issue those writs. This is why they're royal prerogative writs. It was the king's prerogative to use those writs. when we became a democracy, or when Great Britain became a democracy, those writs became available to the public through parliamentary sovereignty to use to challenge decisions. So there's a whole history of common law, particularly in England, into where these principles are developed. And when Australia was federated, there was a inclusion of a right to administrative review within the Constitution. And what happened from federation to 1977 was we had a development of common law, and in 77 we codified the common law in the Administrative Decisions Judicial Review Act, and we attempted to replace the common law as much as possible with a simplified and more simply expressed and hopefully cheaper to litigate set of principles in that act. And what we've seen since then is successive governments, both Labor and Liberal, stepping away from that commitment to review of administrative actions, because governments don't like, whatever their politics are, they don't like being reviewed or challenged. And what we've seen is the power of that act be limited. And we've actually ended up in the strange situation where the courts are now going back to the Constitution and using the Constitution to go back to the old common law writs and the old common law of administrative review, where the government seeks to exclude or limit the court's power to review. And if you remember the discussion on ouster clauses in contract law, one thing you will know is that if there's one thing courts do not like, is someone telling them they don't have jurisdiction. And you'll find that the courts get quite aggressive about finding ways to make sure they have jurisdiction if someone tries to limit their jurisdiction and tell them they can't do that. Anyway, so that's where we sit at the moment. In an ideal world, the common law wouldn't really be relevant because the Act codifies and replaces everything. And we go to the common law for authorities, and we go for common law for inspiration, for what those words mean in the Act, and we can look at a whole history of things like natural justice and what the history of the common law says about that. But we shouldn't need the common law. But unfortunately, we are increasingly looking like needing it in certain circumstances where the government decides that an issue is too much of a political hot potato and they don't want their decisions overturned or reviewed or scrutinised or examined. All right. So what else is in this rather meaty chapter? There's a whole discussion about what a decision is, and that's very important because there has to be a sense of finality and there has to be a sense of a determination of rights in a decision. So just because a government agency says something that you don't like is not enough for it to be a decision. There has to be some kind of substantive legal consequence and final determination. So I'll let you have a read of the cases on that, particularly the Bond case, which is a particularly interesting and important case. In trying to tease out what that actually means. At one extreme, when an administrator says, this is our decision and it'll affect your rights in this particular way, we're fairly clear that that's a decision. On the other extreme, we've got a situation where someone says, oh, I think, in the future we might be looking at doing more of this. And that's a vague kind of statement, and that's not subject to review. It's just merely a statement. And there's a lot of things that sit in between there, and a lot of things that it becomes a very technical issue as to whether it's reviewable. Anyway, have a look at the cases there. There's a little bit on whether something is administrative in character or not, and particularly the one thing, again, separation of powers. I'm sure you're sick of me saying this, but it is the one thing that trips up students all the time in this field, is the is if you don't get the reason why some of these things are divided in the way they are, it does seem very arbitrary. But the reason why decisions of Parliament are not reviewable by the judiciary is because it's not administrative. This is purely legislative in character. Of course, some of those decisions are reviewable through the Constitution. So, for instance, if a parliamentary decision or passing of a law violates the Constitution, of course there is a role of judicial review then, but it is not administrative in character. We're not talking about review of administrative decisions. We're then talking about constitutional challenges, different part of power. I will shut up about the doctrine of separation of powers for now, but it does infuriate me as someone with an admin and constitutional background when you hear politicians all the time completely miss the point and completely miss the real basics of the things that they in their career should know about. You don't expect everyone who's a politician to be a skilled lawyer, but you at least expect them to know what being a representative in Parliament actually means. Or maybe I have high standards, I'm not sure. Anyway, the next topic of discussion is whether something is under an enactment or an instrument. So have a look at that. There's an importance that there has to be some kind of legal documentary backbone to a decision. So if someone has a very broad discretion and they exercise that discretion, there really isn't necessarily an administrative review of that. And this is again when we're talking about general policy, general decisions, general statements of policy. For a challenge, we have to be able to say, well, this is a power that an administrator has. This is where it comes from. Ultimately it comes from legislation. And that's what gives us the ability to review it. Now, sometimes there's an intermediary, and this is when we talk about instruments. So, and again, that was the dog burping, that wasn't me. They're being very active this morning and obviously wanting to participate in this particular topic. Dogs are very keen on judicial review, quite clearly. Anyway, sorry for the distraction. We're talking about instruments, okay? So instruments are things like bylaws or regulations, and they're things that are created under legislation. So there is that additional layer. You have the legislation that's created by Parliament, and then often that legislation will sometimes empower people to do things, but sometimes it'll empower people to create regulation, to create a set of bylaws, to create a set of standards or a code. And that is an instrument, and that is sometimes when other people then come to exercise power, they do it under that instrument. So you say, you have the power to make decisions relating to the classification of vehicles. And you do this under the Vehicles Classification Code that the Minister sets that says, you know, if it has 2 wheels, it's a motorcycle. If it has 4 wheels, it's a car, or something more detailed or technical than that. But you have not just an enactment that says this is you have the power to make the decision. You actually have this instrument that sits in between. And that becomes very important because we don't have a whole lot of scrutiny necessarily over the creation of those instruments. They have to be gazetted. So they have to be published in the Gazette, but I don't know when the last time you were flipping through the Gazette just to see what new regulations were passed. I know I haven't recently. So there's this kind of strange old-fashioned expectation that because we Gazette everything, that ladies and gentlemen of leisure will be flipping through the government Gazette every week and go, oh, this is very interesting. You know, they've changed the rates of tobacco excise. How very fascinating. Today we rely, I guess, more on the media to pick up on these things, or lobby groups or intermediary groups. And that means that a lot of things get through and they don't really necessarily get challenged or scrutinised. And again, this is where administrative law comes in, because we actually have the capacity to go back and review those and to see if those regulations were actually made consistently with the empowering legislation in the first place, or whether they went outside the power that was given to them. All right, so that's a bit about instruments. Again, something to think about. One of the things, it's often a bit of a point of confusion, I guess, for people who are new to the area of law, is that local government is completely administrative in character. We talk about local government being a third level of government in Australia, and practically it kind of is, but legally what it is basically a set of regulations that are made under governing state legislation. And this became an issue a few years ago in Victoria when Jeff Kennett decided to disband all the local councils, and people said, but they're our government, how can we do that? And Kennett said, and he was legally quite right in saying this, it's just under state legislation, and the state government can take the state government giveth, the state government can taketh away, and we can take that legislation away, and then no more local councils. So again, it can be difficult to think about because councils pass bylaws and you think, well, they're sort of like legislation, but they're actually administrative pronouncements. So anyway, something to think about and something to discuss. And again, with all this stuff, if any of this is not clear, ask questions and we'll talk about it. The purpose of these videos is not to be comprehensive, it's just to give you an introduction to the reading so that you can have a read, have a think, and then nut out some of the issues later that are more difficult, that are more confusing. Okay, so it's a little bit on remedies, a little bit on the good old prerogative writs, And being able to talk about certiorari and prohibition and mandamus makes you feel more like a lawyer. They're wonderful Latin terms, even though they're things that we don't use anymore. And there's a little bit about the remedies that are involved in the chapter. So injunctions, declarations, and so on. The one thing that I did want to mention too, and I've flipped past the page that it's on, is, and this is probably a good point to mention it, is that failure to make a decision is also considered a decision. So let's go back to the decision section. I just wanted to mention that, and it does make sense when you think about it. But in the past, one of the ways in which governments kind of avoided being accountable for what they did was, or could do, was to just fail to make a decision. So I'm flipping back to page 19, and section 9.3 says, under section 7 of the ADJR, an application can be made where there's a failure to make a decision within certain time frames. And that's just one thing I think to bear in mind and to keep in the mix, is that if a bureaucrat's response to not wanting to make a decision is just to refuse to make it, we actually have encoded, and this was something that was a little trickier at common law, we actually have encoded in the Act an ability to basically compel them to make a decision. And by reviewing their failure to make a decision. Not making a decision is in fact a decision not to make a decision. Does that make sense? I hope it does. But it's something that's a nice point of clarity to help us understand that every time there are rules, people are going to try and find ways to wriggle out of them. There's going to be ways in which government departments are going to say, oh, well, technically we didn't do that. And more so than any other area of law, admin law is really opposed to wriggling. You know, in private law, you're allowed a certain amount of wriggling, particularly in commercial contracts. You can do a little bit of legal fidgy-widginess. You can actually technically define something in such a way that you get an unfair advantage over someone. And unless it's a consumer contract, sometimes the courts will say, well done you. You've been crafty and you've got one over on the other party by evading or working around the letter of the law. Admin law doesn't work like that, although many bureaucrats think that it does. And they will very often turn around and say, oh, well, you know, if we look at the procedures very technically, this. And there's quite a lot of cases where the courts just say, look, we just don't care. You're obliged to provide natural justice, you're obliged to do this. We don't think you can get out of those responsibilities by wriggling and by working around the technicalities of the section. And I think that's worth pointing that out because that's something quite different to what you're often used to in law. And it's quite different to the kind of image you get of law, particularly through American TV, where it's like clever lawyers build loopholes and people escape from things. It doesn't really happen that much in private law anyway, but certainly in public law, there's much more focus on justice substantially being done than following the letter of the law. The letter of the law is important, but there's very little tolerance of people trying to avoid that. Okay, so have a read of the section. It's a pretty hefty one after the last few weeks. There's a lot of detail in there, but a lot of it is things that it's just ticking it off. It's moving through, yeah, okay, that's what that is, that's what that is, that's what that is. There's not a lot of big questions in this week. It's more just getting a scope of the whole field so that you know where to look later on when you need to know more. Okay, see you in the workshops.